robots are coming for our jobs.
They took our jobs!
AI is going to put all of the artists out of work. Well, maybe not, but AI is already here and it's raising all kinds of ethical and legal questions. Should AI be able to get a copyright over the work that it produces? What would that even mean? And if the AI doesn't own the copyright, who does own the copyright? And what about training an AI using someone else's work such that the AI can produce new works of art that look exactly like the kind of style that a real human artist would produce?
That's my exact style.
Well, we're going to explore all of that today, and we're going to start with the idea of whether an AI can have a copyright in something. And while usually on this channel I say something like it depends, or it's complicated, it depends on the circumstances, the answer here is actually pretty clear-cut. And the answer is no, an AI cannot, under the current law, own any kind of copyright in the work that it produces. Why? Because copyright is reserved solely for human authors. Under the current Copyright Act, the only thing that can get a copyright is an original work of authorship. And courts have interpreted the term authorship to mean a human author. The most famous case that involves this particular issue is probably the so-called monkey selfie case of Naruto versus Slater, where a macaque monkey got a hold of a photographer's camera, pressed the shutter button, and was able to take a photo of itself. The organization PETA tried to litigate the case, claiming that the monkey was actually the author and not the cameraman, and thus the monkey had certain rights to the photo. The courts pretty much universally said, no, anyone other than a human person cannot have a copyright and cannot be the author for the purposes of the Copyright Act. And the answer is no if you're asking the question in your head, can a computer be considered a human person? Computers are not people, at least not for the time being.
I'll see you in court.
Now, an additional issue is that for something to receive a copyright, the work has to be considered minimally creative and expressive. There's a threshold for the minimum amount of creativity that needs to go into a work for it to be considered copyrightable. And this question goes all the way back to a case from the 19th century called Burrough-Giles lithography versus Cerrone that involved the question of whether a photograph could be copyrighted. Now, today we take that for granted, that of course all photographs, whether on film or digital, are going to be a copyrightable form of expression. But back in the day, this was an open question, and people argued that a photograph simply portrays things as they actually appear in real life. But the Supreme Court, and now this has been incorporated into the Copyright Act, assume that a photograph taken by a photographer is going to have the kind of minimal creativity that's necessary for copyrightability, whether it's in the framing, the settings used on the camera, posing of subjects, the selection of the subject itself. All of that reaches some minimal amount of creativity. And when it comes to AI-generated work, whether you're talking about a painting, a video, or something in text, odds are the courts are going to say that that is not minimally creative to the point where it can be copyrighted because it was a computer that did the creation, not an actual human. And there have been several instances where people have tried to generate art using AI and then register that work with the Copyright Office. And they have disclosed to the Copyright Office that it was entirely generated by artificial intelligence. And in those cases, the Copyright Office has denied a copyright in those particular works, citing the lack of human authorship and expressive creativity. And in one very interesting instance, someone actually used an AI to generate an entire comic book based on various prompts that they provided. They actually did get a copyright in that work, but now, having realized that the work was entirely AI generated, the Copyright Office is trying to strip the copyright from that particular comic book. And we'll see what happens there. But at the same time, this isn't a binary dichotomy. This is a spectrum. On one end of the spectrum, you have something that is entirely generated by AI, and on the other end of the spectrum, you have something that is entirely generated by a person. But there's all kinds of ways for people to use artificial intelligence as a tool, and at the moment, it's entirely unclear at which point the court will say that's enough human creativity to warrant a copyright. For example, I can imagine that if I'm doing something in Photoshop and I use the content-aware fill, where I delete out a section of a photo and have the computer replace it for me, if I leave most of the photograph intact, I assume that I'd still be able to get a copyright in that particular photo. And it's at what point where I'm not really putting something in as an input, the AI takes over and the court says, no, you can't get a copyright in that. That's going to be litigated many, many times in the future, and we'll see where the courts come out. But a lot of people are also upset about the way that AIs are trained. And we've seen several instances where if you train an AI on a data set of a particular author or painter's work, the AI does a pretty good job of being able to replicate the style of that artist's work and create new works in that original author's style. And generally speaking, you can't have a copyright over a particular style, but you can get a copyright in individual works of expression. But is it fair or ethical or legal to be able to train an AI using a data set that includes copyrighted work? Because it seems like most AIs are pretty much useless until they've been trained on a very large data set. And usually that involves scraping large portions of the internet of copyrighted work. And if that sounds like copyright infringement, well, it probably is. Reproducing someone's work and taking it from one area of the internet and putting it into a data set is often going to involve what would technically be considered copyright infringement. But that doesn't really end the analysis. Because often, even though something might be considered copyright infringement in the first instance, you might have a fair use defense. And as it happens, there are a couple of potentially analogous cases that involve scraping the internet to form large data sets that might provide the backbone for a fair use defense for all of these researchers who are creating huge data sets and then training an AI on it. The two most famous of these cases involve Google. And the first case is called Perfect 10 versus Google. That involved Google, the search engine, scraping basically the entire internet, including images, and then producing thumbnails in search results, smaller versions of the original images. Now, Perfect 10 was a website that, how do I put this, made money by selling access to photos. And I'll let you use your imagination as to what kinds of photos people would pay lots of money for. They didn't like that Google was scraping their particular website and displaying thumbnails of the images that were contained on the Perfect 10 website. They claimed that this was copyright infringement and they sued Google over it. The courts went back and forth, but eventually the courts found that Google, while it was effectively conducting copyright infringement, because the thumbnails were used for a different purpose than the original images, Google was allowed to do that. Effectively, the search function and display of those smaller thumbnails was not the same purpose that people were using the original images for. The second similar case is called the Google Books case, which is the Authors Guild versus Google. And again, Google was compiling a huge data set of basically every book ever written and then allowed people to search through that database. The Authors Guild was not thrilled with the ability of Google to search through all of these different books. Google argued that it had a fair use purpose in being able to facilitate people looking through all of these books. And again, they weren't displaying the entire book itself, but instead just small snippets of where the particular phrase or word showed up within a particular book itself. And again, the court sided with Google. And while the initial formation of this data set and reproduction of these books might qualify as copyright infringement, the court said that Google was allowed to get away with this search and display because its purpose was for fair use purposes.
Red. Beautiful. You're pushing your luck, little man.
Though that analogy does break down because in both of the Google cases, what Google was doing was fairly descriptive. It was essentially just describing what was already there. AI is different. It's generative. It is generating something new based on prior works. And that might run afoul. We don't entirely know what the court is going to decide when it comes to true AI generation of work based on a data set. The same kind of fair use defense that Google might have in a descriptive context might not apply in an AI generative context. We just simply don't know.
You know something? No soup for you! Come back! 1 year!
There are good arguments on both sides. One might say that what an AI does is pretty similar to what the Google search function does. One might also argue that effectively what the AI is doing is what every single human in the world is doing. They are experiencing art in the world and they are mixing that with their own skills to create a new work of art. Though at the same time, it's entirely possible that this will be solved statutorily, that we might have a carve out in the law that says, while humans are of course doing the same process, if an algorithm in an AI is doing it, we're going to say that's not allowable and there is no fair use defense. These laws can always be changed. And that takes us to perhaps the strangest situation of all, which is that, as we discussed, an AI can't have a copyright in a work that it generates. And it's likely that the people who program the AI also don't get a copyright in the works that the AI generates. But that doesn't solve the issue of copyright infringement, because just because you don't own a copyright in something doesn't mean that you didn't commit copyright infringement. So say, for example, I tell an AI text-to-image generator that I wanted to produce a cartoon of a mouse wearing red shorts, and it happens to produce a photograph that looks strikingly similar to Mickey Mouse. I didn't ask it to produce something that looks like Mickey Mouse. I probably don't own the copyright in that image, and neither does the AI generator. And yet that image still probably infringes on the copyright of Disney because it looks exactly like Mickey Mouse. Who's liable for the copyright infringement in that particular situation? It's sort of anyone's guess. Copyright infringement tends to be a pretty strict liability offense. Theoretically, maybe the programmer is liable. Theoretically, maybe the person who provided the prompt itself. Certainly, if I were to go and reproduce that image and publish it, then I would certainly be liable for the copyright infringement. But there's all kinds of unintended consequences that are potentially possible here that we don't necessarily have a good answer for. And speaking of unintended consequences, right on schedule, the lawsuits are starting to pour in. There are already several interesting lawsuits testing out these copyright issues. The first wave of lawsuits are taking aim at a process developed by Stability AI, which created a generative tool called diffusion, where the program is first trained to be able to reconstruct images that it has been fed. Then it generates new images in response to a written prompt. Stable diffusion is now being used by several companies, including DeviantArt and Midjourney. Getty Images officially notified Stability AI of its intent to sue the company in the United Kingdom for unlawfully scraping millions of images from its site, which could violate UK's standard of fair dealing. Stability AI copied and processed millions of Getty images to train its software. And whereas most AI companies are secretive about where they get their data, Stable Diffusion is transparent. The open source software allowed Andy Baio and Simon Wilson to analyze the training dataset. They found that a large number of the images came from stock image sites, including 123RF, Shutterstock, VectorStock, and Getty, among others. And sometimes the AI even recreated a facsimile of the Getty watermark. Getty's lawsuit was filed in the High Court of Justice in London, and the company didn't say whether they were going to also file a lawsuit in the United States. However, in a press release, the company argued that Stability's actions did not meet the standard for fair use in the US. Getty argues that it's in the same position as the artists whose music was illegally shared through services like Napster. Getty claims that it's not trying to shut the company down, only that they're trying to create some sort of license agreement similar to Spotify, which negotiates licenses with its rights holders. Meanwhile, Visual Artist filed a class action lawsuit against Stability AI, Midjourney, and DeviantArt. The three named plaintiffs are artists whose work has been used to train AI tools. Sarah Anderson is the creator of the webcomic Sarah's Scribbles. Kelly McKernan is an illustrator for games, books, and comics, and Carla Ortiz is a concept artist and illustrator who has worked for Marvel Film Studios and Wizards of the Coast. The complaint was filed in California, and it alleges that the three companies committed copyright infringement by using images owned by the artists to train their image generators and produce derivative works. The plaintiffs also assert claims under the DMCA and unfair competition laws. Now, only the copyright owner has the right to make or authorize an adaptation of the original. The plaintiffs claim that the image generators are simply 21st century collage tools that enable users to make unlicensed derivative works. But the lawsuit's characterization of AI-generated art as a collage seems like an oversimplification. But who knows what kind of analogies a court might use to parse and understand this new technology and its implications. It's an open question whether the generated images would qualify as a derivative or not, and there are good arguments on either side. But the plaintiffs are probably going to run into some of the issues that we already discussed earlier in this video. Images are protected by copyright, but an artist's style is not. Generally, issues of copyright infringement are decided on an image-by-image basis. Now, the Anderson versus Stability AI lawsuit claims, quote, when used to produce images from prompts by its users, Stable Diffusion uses the training images to produce seemingly new images through a mathematical software process. These, quote, new images are based entirely on the training images and are derivative works of the particular images Stable Diffusion draws from when assembling a given output. Ultimately, it is merely a complex collage tool. Now, this section of the plaintiff's complaint really gets to the head of the argument. The plaintiffs are claiming that everything generated by AI is a derivative. Now, a derivative work is an independently copyrightable work that is based on a prior work. So, for example, compare the movie Jurassic Park to the book Jurassic Park. The original novel had a copyright. Michael Crichton had a total control over the novel and also anyone who wanted to make a movie. So, Steven Spielberg had to get a license from Crichton to make that movie, which was a derivative work. Now, the technical definition of derivative is, quote, a work based upon one or more pre-existing works, such as a translation, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. Now, notice the Copyright Act says a derivative is transformed. Now, Now this can get very confusing because if you know anything about fair use, transformed or transformative is basically the same standard. Now the movie Jurassic Park definitely transformed the original novel. But that doesn't mean it's necessarily a fair use. Quite the opposite, in fact. And for the affirmative defense of fair use to apply, it has to be transformative at a minimum, but it also has to be for a separate purpose that the courts recognize as allowable.
I'll allow it.
It also must meet the other four fair use factors. And it gets even more complicated. As one commentator put it, the term derivative work in a technical sense does not refer to all works that borrow in any degree from pre-existing works. A work is not derivative unless it has substantially copied from a prior work. If what is borrowed consists merely of ideas and not the expression of ideas, then although the work may have in part been derived from prior works, it is not a derivative work. And as one court put it, in truth, in literature, in science, and in art, there are and can be few, if any, things which, in abstract sense, are strictly new and original throughout.
Give a hoot. Read a book.
Every book in literature, science, and art borrows and must necessarily borrow and use much which was known and used before. If no book could be the subject of copyright which was not new and original in the elements of which it is composed, there could be no ground for any copyright in modern times, and we would be obliged to ascend very high, even in antiquity, to find a work entitled to such eminence. Virgil borrowed from Homer, Bacon drew from earlier as well as contemporary minds. Coke exhausted all the known learning of his profession, and even Shakespeare and Milton would be found to have gathered much from the abundant stores of current knowledge and classical studies in their days.
It's hard to believe today, but back then, people really did go to the theatre on purpose. And they went to see something called plays.
And really, that's the rub in this particular copyright lawsuit and lots of others, because not everything that's art is new, original, or protectable. It depends. And the Stability AI lawsuit goes on to say, quote, until now, when a purchaser seeks a new image in the style of a given artist, they must pay to commission or license an original image from that artist. Now, strictly speaking, that's just wrong. Artists don't get protection over their styles. You can absolutely go to another artist and say, I want you to paint an image in the style of another artist, but of a completely different subject. And if you did, that would not be copyright infringement. You don't have to pay to commission an original artist to do something in another artist's style, with rare exceptions. So for example, if Van Gogh paintings were still under copyright, if you went to another artist who was not Vincent van Gogh and said, I want a painting of a robot on a starship in the style of Starry Night, you would not have to pay a commission to Van Gogh. You don't get protection over that kind of style. And that's one of the non-intuitive things about copyright. You could absolutely copy something, but if the result looks nothing like the original, then it's not copyright infringement. For example, imagine I'm a painter and I'm trying to make a copy of the Mona Lisa. I have the Mona Lisa directly in front of me, and I try to copy it, but I'm such a terrible painter that it basically just turned out a smiley face. Now, I literally tried to copy another work, but I also basically failed. And even though I actually copied it, it's not infringement because my painting looks nothing like the original Mona Lisa, assuming the Mona Lisa was still under copyright. And that's because the standard for copyright infringement is usually explained something like this. A plaintiff must first show that the work was actually copied. Second, they must establish substantial similarity or that the copying amounts to an improper or unlawful appropriation. Now, it's a whole ballgame as to what constitutes unlawful appropriation, but usually it goes something like, it was protectable expression of the earlier work that was copied, and that the amount that was copied was more than de minimis, more than just the minimal amount that law doesn't actually approve of. It gets extremely complicated. But now I think you can see a lot of the actual issues at play. Was there actual copying for the databases that were used to train the AI? Yes, and that's copyright infringement unless there was a fair use defense. And there could be under the Perfect 10 and Authors Guild cases. And then the additional issue of, is art that is generated by AI based on these trained images, is that necessarily a derivative work? And does that infringe on the original work's copyright? And that's an open question too. Maybe, but probably not. And that's because copyright is almost always done on a case-by-case basis. You have to look at one image and compare it to the original image. And only then, generally speaking, can you make a determination as to whether there is copyright infringement. Generally, you can't say, I'm looking at the process and not looking at the output to make a determination that everything generated by this process is necessarily infringement. The defendants here might concede that there was actual copying, but that's not the end of the discussion, that's merely the beginning of the discussion. And speaking of which, that's also just the beginning of AI shenanigans, because there's one guy who claims that he can replace lawyers with AI chatbots. Now that's super dumb. So I made a whole video about how dumb that is, and thanks to the power of today's sponsor, Nebula, you can watch my video about that right now, even though it'll be weeks before I release it on YouTube. Ladies and gentlemen, we've just lost the picture, but what we've seen speaks for itself. It's already available to watch on Nebula because my videos always go up on Nebula first. Plus, on Nebula, there's tons of exclusive content. For example, when you sign up for Nebula directly, you get access to Nebula classes, which includes my entire course, How to Sue Like a Lawyer. That used to be hundreds of dollars a year, but now it's free and included with your direct Nebula subscription. And that's just one of tons of exclusive videos that are available only on Nebula. And I make exclusive content all the time. Because what's truly special about Nebula is it is a creator-owned platform built by me and other YouTubers, and because it's a subscription service, we get to work on larger, higher budget productions than we ever could on YouTube. It's some of my absolute favorite videos, and it's almost all Nebula first or Nebula exclusive. And if you sign up using my link that's on screen right now or down in the description, you'll get a $10 discount a year, which means it'll cost you only $3.33 each month. You'll get access to my videos early, get access to exclusives, and you'll be able to support the ambitious projects that my friends and I are working on in our own streaming site. So sign up right now by clicking on the button that's on screen right now, or click on the link that's down below in the description to get a huge discount for Nebula. And after that, click on this box over here for more LegalEagle, or I'll see you in court.